lead attorney representing the group of 11 parents who sued the school district to prevent the teaching of intelligent design in public school classrooms. Mr. Rothschild is a partner at Pepper Hamilton in Philadelphia. He graduated from Trinity College at Duke in 1989 and attended law school at the University of Pennsylvania. Mr. Rothschild has 11 years of experience in commercial litigation. His talk today will focus on how that experience helped him successfully try this First Amendment case, which he and his law firm took on pro bono. He'll speak for about 20 minutes and then answer your questions. Mr. Rothschild is also giving the Provost Lecture this afternoon at 5 o'clock at the Levine Science Research Center. There are flyers for that talk outside the room on the pizza table for anyone interested in attending. Please help me welcome Eric Rothschild.
Thank you, Professor Ludington, and thank you all for being here. I see the first few rows are as popular as when I was in law school. I am going to be speaking tonight at the Levine Science Building, and I encourage you to come. That's the presentation with all the bells and whistles, PowerPoint, tapes, and all sorts of things like that. And what I try to do in that presentation is really take you inside the trial and understand how we were able to win the case. What I'd like to do today is tell you a little bit about my own background as a lawyer and as a litigator, and how this pro bono case, Kitzmiller versus the Dover Area School District, fit into my practice and how my practice helped us succeed in this case. As Professor Ludington said, I graduated at Duke in 1989, and I couldn't name for you now the one science course I took to fulfill my requirements to graduate from Duke. I'm a fairly unlikely attorney to have had a case which many look at as defending science and science education. Happily for me, I did meet a woman here who actually did take science courses at Duke. She became my wife. She was a 1988 graduate. I chased her up to Philadelphia, where she had started medical school and would eventually become a pediatrician, and we're married, so that's one of those happy Duke stories that you often hear about. I went to the University of Pennsylvania Law School, and like many of you, during after my second year, was looking for a law firm that I would be happy practicing in, first as a summer associate and hopefully for a long time after that. And I felt incredibly naive about the whole process. I really didn't understand what lawyers did other than those you see on TV and sort of the most high-profile constitutional arguments that are a big focus of your legal education. But there were two things that I felt were important to me beyond just feeling comfortable with the people I was meeting. One was I wanted to be a litigator because I really thought that is all that lawyers do. I didn't really have a good understanding of any other thing lawyers could do, and I never really opened my mind to transactional practice or trusts and estates or anything like that. So for me, I wanted to go to a very good litigation firm. And the other thing that was important to me was going to a firm that really valued pro bono work. And that was important partly because a lot of the really interesting constitutional policy cases are played out in that way with pro bono representation. And also, I called it my liberal guilt criteria. I'm going to a big firm. We all understand if you're doing that, one reason you're doing that is because those firms pay well, and they also do really exciting work, whether it's litigation or transactional work. But I felt for balance for myself and to meet my sort of own expectations of myself, I wanted to go somewhere where pro bono was an important part of the practice. And the law firm I chose in Philadelphia, Pepper Hamilton, was a great example of that. It's hardly the only example of that, and there were other firms that I was considering that also had a strong pro bono commitment. But that was very clear as I met people at Pepper and read about them. They had been involved in the reproductive rights cases that had gone to the Supreme Court out of Pennsylvania in the early 1990s. They had been involved in the prison overcrowding litigation. So this was a firm I knew cared about doing it, did really interesting cases, and that was important to me. And I've now spent, I guess, 12 years as a practicing lawyer after clerking for a judge for a year after graduation. I'm a partner in the litigation practice. And in both ways, you know, the things that were important to me as I selected a firm have been fulfilled. In terms of my general litigation practice, I've actually done a pretty wide variety. When I first came to the firm, I focused on actually science-type cases. I was sort of even more a fish out of water there than I would be in the intelligent design case based on my sort of undergraduate education. But I learned in cases involving radiation exposure, vaccines, other products liability cases, how you litigate a science case, the amount of effort you have to put in to understand the science that's relevant to whatever issue you're litigating, and how to present that to a court so that it's understandable. And during the course of my career, I've practiced in various areas of commercial litigation, and in many respects, it's the same. Whatever complex area of litigation you are involved with, you really have to learn that business, whether it's science or a commercial practice or whatever it is. There's no way to be a good trial lawyer unless you really learn the area extremely well. So when you're cross-examining an expert or putting on your own expert or somebody who's involved in the business, you understand that area, maybe not quite as well as they do, but pretty close, so that you're intelligent in your questions and you're nimble up there as you're asking questions. No matter where the answers take you, you're ready to respond to them and pursue your line of questioning. And then in terms of pro bono practice, I've had various types of pro bono practice. I was involved in the prison overcrowding litigation. I've brought free exercise challenges on behalf of immigrants. And then in 2004, I really had the opportunity to take the case of my dreams. When I was you guys 13, 14 years ago, and if you'd asked me to describe a case that you could be involved with, that would really make you happy, that would be really make your legal career stand out, it probably wouldn't have been much different than the case that I became involved with, which was Kitzmiller versus the Dover Area School District, the intelligent design case. I don't know how much all of you have studied it, but I'll give you a little background about the case. In June 2004, a citizen in Dover named Barry Callahan, who would become one of our clients, and she was a former school board member, stood up at a public school board meeting and asked the board members why they had not approved a new biology textbook for 9th grade, which was the grade that her daughter was currently in. And this is actually something she'd been agitating about for a number of months. And the board hadn't really given very helpful answers during those earlier months, but in June they made very clear what the problem was. In particular, one school board member named Bill Buckingham, who was the head of the curriculum committee, told Ms. Callahan and the audience that the biology book that he had reviewed was laced with Darwinism, which actually for a biology textbook is not a bad thing, but I don't think he meant it as complimentary. He said, "I challenge you to trace your roots to the monkey you came from. This country wasn't founded on Muslim beliefs or evolution. It's founded on Christianity, and our students should be taught as such. 2,000 years ago, a man died on a cross for us. Can't we stand up for him now?" And he wasn't saying that as a general point. This was about the biology textbook. And he and other board members expressed their desire for creationism to be taught alongside evolution. And these statements were reported in 2 local newspapers, and their accounts were extremely consistent. After that, Mr. Buckingham got in touch with a lawyer named Richard Thompson. And Richard Thompson was formerly the Attorney General for the state of Michigan, who was best known for his serial unsuccessful prosecutions of Jack Kevorkian, the assisted suicide doctor. Right after Mr. Thompson left office, his successor was able to actually successfully prosecute him. And Mr. Thompson, at this time, was the chief counsel for an organization in Michigan called the Thomas More Law Center. It had been founded by Tom Monaghan, who had formerly been the owner of Domino's Pizza and is a well-known conservative philanthropist. And the Thomas More Law Center is very blunt about what their mission is, which is to defend the rights of Christians. They call themselves the sword and shield for people of faith, which we always thought was sort of a helpful little fact in a case where they kept claiming this was about science and not religion. Mr. Thompson, the Thomas More Law Center, was looking for a school district, and had been for a number of years, to teach from this book of Pandas and People, which describes itself as the intelligent design textbook. And they wanted, they were actually spoiling for a legal challenge to the teaching of intelligent design and from Pandas and People, and Mr. Buckingham became that test case. He recommended to the school board that they purchase of Pandas and People, and the school board didn't actually end up purchasing it, but they agreed to accept a donation which was portrayed to the Dover community as being anonymous, and they never told members of the Dover community where it came from. And in fact, when we took early depositions of the case, we asked Mr. Buckingham and the school board president, Alan Bonsell, whether they had been involved in any way in the funding of this anonymous donation, and they were emphatic, absolutely not. We later found out that Mr. Buckingham had stood up in front of his church before services and asked for donations for the purchase of this textbook. And he collected $850 and wrote a check to Alan Bonsell in that amount. On the bottom it says, for purchase of Pandas and People. And he handed that check to Alan Bonsell, the school board president, who gave the money to his father, who was actually the person who made the donation. So they had denied any knowledge about the funding, and in fact, they had been the people who did it. And at trial, when my colleague Steve Harvey was cross-examining Mr. Buckingham, he actually, after going through the facts of this and getting Mr. Buckingham to admit he actually had done this collection, pointed his finger at Mr. Buckingham, and you don't do this often in court. He said, "You lied to me at your deposition, didn't you, Mr. Buckingham? You lied to me." And Mr. Buckingham said, "What do you mean?" And Steve followed up with a couple more questions, and it wasn't, there was no more headway. And then the judge interrupted Steve and said, "Mr. Harvey, you've made your point very effectively, very effectively." So that was not an admonishment of Steve. That was, I get it, move on. And then when Mr. Bonsell was cross-examined on the same subject, Steve was not quite as dramatic about his cross-examination, just established the points, didn't want to overdo it. But after that was done, the judge, Judge John Jones, who was presiding over the case, said to Steve, "Could you give me a copy of your transcript? I have some questions." And Steve said, "Oh, can we get it to you overnight? Mine's kind of dog-eared, And the judge said, "I want that transcript now." We had great legal assistance, and they found a clean transcript. And then the judge proceeded to examine Mr. Bonsell for about 10 minutes about why, and I had been the one who had actually taken the deposition of Bonsell, why he hadn't told me about him accepting the check and his role in the donation. And it took Bonsell about 3 minutes to realize what was happening to him, while the rest of the courtroom was sitting there. You almost couldn't breathe. I mean, Alan Bonsell was probably the witness that I had the least sympathy for throughout the whole case. He sort of reminded me of Biff the bully in Back to the Future. But even I was sitting, I was uncomfortable, and everybody who was in that courtroom sort of afterwards said, "Was your heart beating a lot faster when that was going on?" Because the judge, who's a very congenial guy, really ran the courtroom, in a very relaxed fashion, was red-faced and angry about it. Just going on with so that's sort of the background of Pandas. After they accepted the donation of Pandas, they then passed a policy in October of 2004 amending the biology curriculum to require that students be told that there are gaps and problems in the theory of evolution and that there are alternative theories of evolution, including intelligent design. And the science teachers in the district spoke out against this policy. And after the policy was passed, the school administration prepared a statement which basically sort of had two parts. One which sort of told students that evolution's fishy, don't believe it, and the other that promoted intelligent design as a scientific alternative and referred them to Pandas. And this was supposed to be read by the science teachers to students at the beginning of the evolution section of biology class. The teachers refused to do it. They said it would violate their ethical obligations. So it ended out that it was read by administrators rather than teachers. And the teachers were really pretty heroic figures in this whole story, both in standing up to the administration and the board in that respect, and then testifying on our side in the case at trial. We, after this policy was passed, parents started to call the ACLU, American Civil Liberties Union of Pennsylvania, asking what they could do about it. And ultimately, we got in touch, my law firm, Pepper Hamilton, got in touch with the ACLU and volunteered to work with them on this case. And we really pulled together a team of lawyers and consulting experts that was really worked together remarkably. It was my law firm, the Pepper Hamilton. We had a number of lawyers work on the case, the American Civil Liberties Union, Americans United for Separation of Church and State, and a small organization in Oakland, California called the National Center for Science Education, which works as like an evolution watchdog group and was our sort of consulting experts in the case. I mean, as I said, I'm not someone who has a lot of science education, so what I was able to do with the scientific evidence in this case was, sort of largely based on their tutoring, and they were excellent. And there was actually an article in Harper's Magazine, and I'm not sure where Professor Litigating put it, but I have some materials, including the article from this case. And it was written by Matt Chapman, who's actually Darwin's great-great-grandson, and who was there for almost the whole trial and wrote this article. And that was sort of one of the many thrills of being part of this case, was getting to know him. And he described this legal team we'd put together as working together with frictionless amiability and like a collegiate machine. I think he meant collegial machine. We're not like Duke basketball. But it was extremely flattering nonetheless, and really reflected how we felt about the case. And it was, I mean, this case, one of the things that I've always come out of it with is that, this was a really important constitutional case. The issue of teaching evolution has been one of the fault lines for separation of church and state. But more than that, it was a real trial lawyer's case where more than the legal standards, it was discovery, litigation strategy, and trial presentation, which are really the things that's sort of, at our law firm, that's sort of the meat and potatoes, taking a complex case, making, decisions in discovery, putting together expert evidence, and then trial presentation. That's really what we do more than, being First Amendment scholars. Those legal standards were important. We had to understand them, but it was really a trial lawyer's case. We put together, sort of an interdisciplinary expert team of biologists, paleontologists, a theologian, a philosopher of science, a historian of the intelligent design movement, and an expert in education. And that was a great part of the case, working with them. And then we had this sort of fascinating small town story that we also had to gather evidence about and present at trial. One of the reasons I'm here and why Duke has asked me to speak at the Provost Series is this is an issue that captured all of the, the public's attention, and that is certainly another aspect that made it exciting. I sort of realized from the outset that this would be, a fairly high-profile case, but it really got reinforced in I think it was August. I was on vacation in Rehoboth, Delaware, and I got a call on my cell phone from one of my legal assistants on the case, and she's squealing, "You're in Time Magazine!" So I went to a bookstore and I got a copy. Well, I got 10 copies, and there I was up there in the right-hand corner. This is a shot from the press conference with Charles Darwin and George Bush, and in an article called "The Evolution Wars." I always have this idea that everybody has a little, thought bubble in their head, and mine says, "Wow, it's Charles Darwin and George Bush," and George Bush is looking up and says, "Who are those two guys?" That kind of media attention continued throughout the trial. There was no jury in this case, so the jury box was filled with the press, and some days they much overflowed that and were in the gallery as well. There was, the New York Times, there was actually great coverage from the local York papers. There was a columnist named Mike Argento who very funny, we described him as our H.L. Mencken from the Scopes trial, only Mike had many more stoner references in his columns than H.L. Mencken ever did, but he was actually very funny. And there was even a researcher from Paramount Pictures who was there throughout the trial, and that sort of allowed us to engage in every night in the parlor game of who's going to play you in the movie. And just from a personal standpoint, my role in this case, I was the lead trial counsel, and when I say that, this was, as I said, this was an incredible group effort, and myself and my colleague Steve Harvey and the ACLU legal director Vic Volchek sort of all, in some respect, were lead trial lawyers with important, taking a number of witnesses in the case, and we had other lawyers who took a smaller number of witnesses. But sort of among that group, I had the status as the lead trial attorney. I did the opening and closing statements. I put on many of the important witnesses, and then probably the highlight of the trial for me was I cross-examined Michael Behe, who was sort of the lead scientist in the intelligent design movement. They really don't have very many scientists, period, in the intelligent design movement. It's a lot of sort of philosophers and religious people, but they do have a few scientists, including Professor Behe, who is a professor of biochemistry at Lehigh University. He once actually did real biochemistry, but in 1996 he wrote a book called Darwin's Black Box, which basically makes an argument for intelligent design based on the complexity of biological systems in the cell. And that's pretty much all he does now. And there's no research, there's no peer-reviewed scientific articles, there's no laboratory research, but he basically makes an argument that because of the complexity of certain systems in the cell, they must have been intelligently designed rather than developed through natural selection. And he testified, he began on a Monday, he was the first witness for the defense. He testified all day on Monday and until about 2 or 2:30 on Tuesday, and I felt like a caged animal. I was really prepared to cross-examine him. I'd already taken his deposition and had really prepared hard with the people at NCSE and our scientific experts to take his cross-examination. I think I came out of the box a little bit hyper in his cross-examination, but ultimately this was actually sort of probably for me personally the standout accomplishment in the case over more than a full day of cross-examination, going at it from various angles, which I'll discuss a little bit more at the lecture tonight that you're all going to come to. I was able to really dismantle his argument that what he was doing, or that anything in the intelligent design argument, is really science. And in fact, as sort of one of the low-hanging fruit, I got an admission from him that if intelligent design is a scientific theory as he defines it, so is astrology. So, sort of one of the other highlights of the trial for me, there was an article in the New Yorker after the trial but before the decision, and it has a caricature of me cross-examining Behe. It makes me look very tall and slender, which I'm happy about. And it says, at the trial, Michael Behe, the leading intellectual of intelligent design, was cross-examined with cheerful mercilessness by Eric Rothschild. For all you aspiring litigators, that's about as good as it gets. I think I'm mercilessly cheerful. They say cheerfully merciless, tomato, tomato, either way. When Judge Jones, who presided over this case, he's a 2003 appointee of George Bush, and really, I just like him a tremendous amount, and I think I would be saying that if we hadn't won the case. And he's been doing some public speaking on the case, and he said sort of generally about the case that a lot of good lawyers, this was like the playoffs in sports where good athletes raise their game, and he said that, and I don't think this is, I think this actually is something he was saying not just about me or our legal team, but even the defendants' lawyers as well, that good lawyers raised their game in this case. I think we all recognize, as did the judge, that this was really sort of a historic platform, and we all sort of rose to that occasion, and it was a really an exciting trial. And then the trial ended in early November, and then on December 20th, the judge had given us advance notice that the decision would be coming out. He was pretty media savvy, and he knew that people would want to cover this. And so we were all gathered at Pepper's Harrisburg office waiting for the decision. And it's not, you don't get it, when the movie gets made, it'll be issued in the courtroom, and there'll be hugs and everything. That's not how it happens. Actually, you just get an email with the decision attached. So we're all sitting there waiting for it, and the decision comes across, and we get he didn't have the result right at the top, so you got to scroll all the way to the bottom. Okay, we won, very excited. It was really important to us how we won. We wanted to win the case. A home run was just winning the case for our clients, but a grand slam home run was a complete sort of dismantling of intelligent design, a declaration that it's religious and not scientific. And as we read through the opinion, it's clear that that's what the judge did, and that was very exciting. But there was nothing more exciting, and probably nothing that sort of imprinted on my memory more than our clients coming in groups of one or two. As the day went on, we were having a press conference that afternoon, and most of them came. And so they would come in. Tammy Kitzmiller, who was the lead plaintiff, was the first one in. And I can't tell you how much I like my clients in this case, how much conviction they brought, how interesting they were, how courageous they were. And they're actually just fun people. I like to go out for a drink with them. So it was, and to see the looks of sort of relief and satisfaction and vindication on their face, because the judge, he had really, he had understood that, the way the board members had behaved here, he had really called them out as liars. I mean, there's no other way to put it. And just seeing each of them, as they came in and the hugs, and then many of them spoke at the press conference, and as they had been at trial, they were just profound in the way they expressed their feelings about this issue and what had happened in their community. And it was, this is one of those cases that everybody pays attention to because the issue is important to everybody. It has this long history from Scopes, and we understand that it's being raised again in a time when religious views are at the forefront in the political community. So at one level, it's a cause, and it's easy to forget that there were actually people in this community who were disturbed by this, who thought it was damaging to their kids, and who decided to stand up and do something about it, and felt in the end that, first of all, they found lawyers who would stand with them and do a good job for them, and then a judge who really obviously heard their words and listened to the case and sort of vindicated their confidence in the whole system. And that's in a series of, in a case which brought many thrills and feelings of accomplishment for myself and my colleagues. That was the best. I'm happy to take any questions.
So I've been told that in a constitutional case, there's little that matters as much as how you define the record that you're trying to try the case on. I wondered if you might speak on how you decided to build the record that you did, why you felt the particular things were important, and then also how you felt that the record build, the decision process in that strategizing was different from your commercial cases.
It's actually, I do some constitutional cases. I don't do a ton of constitutional cases, and many of them I think, really have a fixed record. It's a statute that's being challenged, and there, it's more of a legal argument. What's the right legal standard to be applied? And this was a case where we felt, that we actually, I think, tried it the way we try our commercial litigations or our major product liability cases, where we got down into the facts, both the facts at the community level and the facts at the sort of national intelligent design movement level and the scientific facts. And we used, people sometimes call our case the Scopes trial too. And it was actually, this case was different in almost every respect than Scopes in that, first of all, we won. And second, that in Scopes, Clarence Darrow wanted to put on the kind of science case we did, but was not allowed to by the judge. And we actually used as probably our biggest model a case called McLean versus Arkansas, which was about a creation science. It was actually legislation, not a single school district. And they wanted creation science taught alongside evolution, much like intelligent design in this case. And in that case, in addition to sort of bringing out all the facts about what went on in that community, both sides put on this sort of robust expert case. The late paleontologist Stephen Jay Gould was one of the experts for the plaintiffs. Francis Ayala, who's a prominent scientist, Michael Ruse, a scientific philosopher. We sort of built our case in a similar way as that, to have this interdisciplinary legal team. And you know, the other thing we were very sensitive to is when you try a case like this, you've got to have themes that you carry throughout the trial. And you know, one of our themes was good science education, but the other was religious liberty. People would sometimes, you know, when I first got this case, people would call this my lawsuit against God, and they would pretend they didn't want to stand right next to me on a stormy day. But it really, I think they were pretending, and I think it was about this case. But we were always very conscious. It's not really a case against religion. It's really a case about religious liberty. It's a case about the right of each parent to bring up their children in matters of faith without interference by government officials. And partly by coincidence and partly by design, our group of parents and our group of experts really reflected that. We had some parents who I think, you know, if you put them under a lie detector test, say, I'm an atheist, I don't believe in God, or I certainly don't do anything to practice. And we had one couple who were plaintiffs in the case, they teach vacation Bible school. In our group of experts, we had some experts who are not religious at all. And then, for example, we had Ken Miller, who's a biology professor, and he's a devout Catholic, and has written a book called Finding Darwin's God about how he reconciles those two aspects of his life. And so we're very conscious that you needed, we'd never want to be portrayed as the proponents of atheistic evolution. We don't think evolution has a religious side one way or the other. We never wanted to be the science versus religion side. This is a case about religious freedom, so we kept that theme very much in mind. And you really have to remember, when you try a case, I mean, the presentation, it's not just as simple as meeting your elements. You got to think about, how does the whole thing hang together, and tell a story, to have a narrative. And I mean, I think it's what we do in our day-to-day commercial litigation fair, and what we try to do here.
Well, it's possible. It's possible to treat intelligent design as a scientific theory if you manage to conduct experiments that would adduce evidence to prove or disprove it. Unfortunately, I'm not familiar with the record in your case, but I had a question whether the defendants adduced any evidence to at least argue that intelligent design should be viewed as a scientific.
They did. They presented two scientists, Michael Behe, who I described, and a microbiologist from the University of Idaho named Scott Minnick, and they made their argument that intelligent design is science, and it's hard to go into huge detail about it here, but there is, I would call it, there's sort of a scientific facade on intelligent design. Professor Behe, and particularly Professor Behe, advocates this argument. He has an argument called irreducible complexity, which basically, in very general terms, is that there are systems in the cell that are too complex to be explained by natural selection. Therefore, there must be intelligently designed. And I could speak for an hour about everything that's wrong about it, but
whether they actually had any experiments?
No. Answer, no.
Okay.
No experiments, no peer-reviewed scientific literature, no production, no tests, and I think this is the point that I think you can sort of end the inquiry much quicker, and that is intelligent design makes the argument we have to redefine science to include supernatural causation. And science doesn't operate that way, okay? Science operates on a principle called methodological naturalism, natural causes for natural phenomena. Doesn't mean that there's no such thing as supernatural, it's just outside of science's ken. And I think intelligent design is disqualified right out of the gate for that reason. And the judge thought that was the most important fact on the scientific issue as well.
I guess, so theoretically, where is the appropriate box for this type of, for this philosophy? That's what it comes down to, right? That it should be taught in theology class or in philosophy class, and not as a science.
That's clearly right, that if it is going to be taught at all, and you can, I think there's a sort of interesting legal question about sort of where religion can fit into a public school curriculum. I think theoretically a comparative religion class would be actually phenomenal. I have real concerns about how it's implemented district by district, but certainly a legitimate, neutrally presented comparative religion class would be appropriate. Here's what I think. I've read theologians, and including our expert witness, Jack Haught, who actually spoke in the Provost series earlier this year, and he would say, and I think many theologians agree, intelligent design is incredibly problematic from a theological perspective as well. In other words, if this was something that you were going to talk about in church, there would be a lot of theological problems about it. That's sort of a separate issue. My guess, look, I think intelligent design is just a Trojan horse for a desire to teach creationism and to cause students to not accept the theory of evolution and to believe that man was specially created. I think I don't think this is really, the intelligent design itself is anybody's theological goal. It's a means to an end. So, in other words, if one were to teach this from in a comparative religion class or theological perspective, I think the advocates of intelligent design would just say, let's get back to straight creationism, the Bible story. I mean, in other words, intelligent design is just a Trojan horse for that, but that is the box it would fit in if it fits anywhere.
In watching this case, it seems to me that intelligent design largely becomes, I agree with you, a Trojan horse for creationism, but it seems like the intelligent design people sort of shot themselves in the foot by making these public statements about their real intent to get God back in the classroom. And I wonder if the effect of this case just isn't to produce a third wave or a fourth wave of smarter creationists.
Right. And I guess there's sort of two parts of that. One is you had in this particular case school board members who were sort of outside the control of the intelligent design movement when they started out, saying these incredibly provocative things. And what played out at trial was they just lied and said they hadn't said them, and then and then we just brought in overwhelming evidence that they had in various forms. And so that was something that maybe is somewhat unique to this case, though my feeling is that if you ever find a school board who's sort of focused on diminishing the teaching of the theory of evolution, maybe bringing alternatives, if you dig hard enough, you're probably going to find there's a religious motivation because there's really no legitimate scientific controversy over it. And one of the things I said in my closing statement was that even if these school board members had been more circumspect or better at covering their tracks, it wouldn't change the result you have to reach, Your Honor. Intelligent design is an inherently religious, non-scientific theory. And I was saying to him, and he obviously got there, is don't just decide this on the local facts, go after all of it. And so then you have another piece of this, which is the intelligent design movement actually has there's a lot of evidence of their religious intentions, which, over time, I guess they can distance themselves from. I mean, just as one example, and this was probably the most compelling piece of evidence in the case, this book of Pandas and People, which holds itself out as the intelligent design textbook, its proponents say, this is not creationism. Well, we subpoenaed the publisher of this book and got drafts of the book, and what we found was that everywhere intelligent design was used in this published version, in the drafts, they used terms like creation, creationism, and creator. My colleague at Americans United, who was sort of our lead brief writer in our response to summary judgment, said they replaced creationism with intelligent design with all the elegance of a word processor's algorithm. And that was a very, a very evocative way to describe what had happened here. The book was written as a creationist book. Then Edwards versus Aguilar was decided in 1987, which said teaching creation science was unconstitutional. And they didn't have word processors and algorithms back then, but that's what happened. They changed creation for intelligent design. That fact doesn't go away. And so and then, the intelligent design sort of biggest modern advocates, the Discovery Institute in Seattle, had a strategy document called the Wedge document, which is basically all about a religious and cultural agenda for replacing the teaching of evolution with the teaching of intelligent design. That doesn't go away. Does time get them removed from that? I don't know. If they want to remove themselves from it, they got to produce some real science. But yes, people will be more, will conceal their motives a little more. Actually, even before the trial started, the intelligent design movement, including the Discovery Institute, was saying, hey, we don't really want intelligent design taught. We want the controversy over evolution taught. We want critical analysis of evolution taught. Those are just new, less inflammatory labels for the same arguments that comprise creation and intelligent design. And one of the happy things we've seen happen after the Kitzmiller cases in Ohio, Utah, and South Carolina, those kind of anti-evolution curriculums have been rejected. And those aren't, that's not, San Francisco. I mean, these are, pretty conservative areas. So we've seen a good impact, and not just on the specific, with the specific terminology of intelligent design. We've seen it even where these less, these less obvious labels are used.
Remember the happy epilogue to all this is the creationist school board was thrown out of office very shortly after you won. And I'm wondering, the feeling I get from what happened in Dover is that you had a very energized minority of people who wanted this, who wanted creationism to be taught. And because a lot of people just don't vote in school board elections, if they were able to energize themselves, they were able to control the board. I'm curious as to how general that is. I mean, what's your sense nationwide as to how, as we see people with theocratic bents to their politics being elected, is that because there's a narrow minority that's able to take advantage of the fact that a lot of people aren't voting? Or are there places where you might have a tougher time than Dover because there actually is popular support?
Well, I actually think in Dover, it was probably always really split down the middle, that it was not a, people didn't just represent 10%. They probably did represent half. Now, they came into office, I mean, your point generally about sort of vigilance over school board elections, which frankly, I have kids in school and I pay almost no attention to those, sort of down ballot races. I'm very attuned to national politics, and I don't pay that much attention to the school board because in a busy life, I just don't do it. I'm not particularly proud of that. And in this case, the people who went on the board and supported intelligent design won on the issue that probably 99% of school board elections are decided on, and that is fiscal responsibility, a building project. I mean, how much money are you going to, how much money are we going to put into building the new high school? I mean, that's what they got in on. And I think, the school board election, which actually happened after the trial, but before we got the result, I think it was probably actually reflective of a community that still was basically probably split on the issue as a general matter. The race was pretty close, but they had seen this school board member, the trial exposed these school board members as selfish, as dishonest. And so I think that, if you don't have the trial and you just have the issue, I'm not sure the board changes. I think what happened here was these board members were portrayed in the community. First of all, this looked horrible in the trial. And then they also, even if they had been, sort of carried themselves better in testimony, they really dragged their community into, this mess. It's expensive. So I think that, I'm not sure without the trial you get that change in school boards. So I have to say, as the representative of parents whose kids are in the school board, it was a very happy epilogue.
Did you receive any like threats or just really people that were just way out there kind of attacking you personally or whatever?
It's
the team in general.
I got almost nothing. I got a lot of supportive emails. I got one email that just said "loser" on it, and whether that has anything to do with that case, whether it's from a family member, I have no idea. And so, I got a few weird letters and this sort of like, very convoluted religious language, but nothing nasty. And, I'm Jewish. I sort of thought, that I might sort of get targeted in that way. one of our plaintiffs has gotten some pretty nasty stuff, and I never have, and I'm a little surprised by that. Judge Jones got, threats. He actually had martial protection for a while, and I sort of expected, and I'm doing a lot of public speaking on this issue, so I'm sort of out there on it. I sort of expected that, and I'm happy that that really hasn't occurred.
How many hours did you spend, or did your firm put forth litigating the case?
A normal year, sort of billables for me is about 2,000 hours, and 1,900 to 2,200 hours. And this year I probably billed a total of 2,200 hours, and about 1,300 of it were on this case. I was certainly at my firm the person who spent the most time, but it was an extraordinary amount of time. And I do think, we really super lawyered this case in the sense of putting a lot of resources into it to the benefit of the case, but we had a lot of people working on it. And that's not even including the ACLU and Americans United, who also contributed tremendously. Peppers, we got an award from the judge of $2 million in legal fees, and that actually was and then we accepted $1 million to sort of satisfy that. The legal fees for the groups were much higher than that for just a year's worth of litigation. It was a tremendous amount of time and resources. And the firm was incredibly supportive of this. And it's, as I said, and this is, you can take this as a commercial for the firm and, pick up our materials, because I hope some of you will consider us. This is a strength of this firm. Most firms allow pro bono. This is a firm that it's part of the culture. It's who it wants to be, and it has taken big cases before. And obviously, now in retrospect, this is a great thing for the firm. You just don't get this kind of publicity for almost anything you do. I expected this case to be a big deal, but I'm sort of astounded at sort of the ongoing attention. Paramount Pictures is really going to make a movie about this, it's being written by the same writer who did The Pianist. So this is a serious writer. There's going to be books written about him. It's amazing. So it's really turned out well for the firm. From a personal standpoint, it meant in my specific practice, a lot of other people sort of had to pick up the slack for me, and that people do that, but it was, that's hard. That's the hard part about it, is that, last year I wasn't much of a sort of practicing, money-making attorney. And I continue to, I'm now back to my practice, but because I'm doing a lot of public speaking, it still takes a lot of time. But the firm, the firm was always behind it. They got more and more excited about it as the attention grew and our trial performance was strong. And it's definitely been a happy thing for the firm. And I think, people like it that their firm did this. And I hope that, I've been to a number of law schools, and Steve has as well. And, I hope, when I was a law student, if you told me, do you want to go to that firm? They did that case, I would have been like, that's my firm. I want to go there. And so I hope people feel like that, in groups like this.
Who's going to play you in the movie?
Well, it's funny because, you have a lot of strong-willed people on this legal team, and every one of them agreed George Clooney. It was... Everybody always laughs at that one. People have actually, when I was younger, used to always say I look like Richard Dreyfuss, and I never quite saw it, but a lot of people say that, but obviously he's quite a bit older than me. But, as long as they get my name in there, it's good enough for me.
Hey, two quick questions. The first one was about the original textbooks that I think that you said the parents protested those. Did those actually advocate intelligent design, or did they just say that here's evolution, many people don't accept this, there's many problems with it?
The textbooks that for example, Barry Callahan, who was this parent who became our client, was advocating, was a standard biology textbook, just teaches evolution. It was actually written by Ken Miller, who became one of our experts in the case. It's just your standard biology textbook. So, and maybe I wasn't clear about it. Barry was on our side of the issue. She wanted good biology textbooks for her students because they had outdated textbooks. It doesn't teach creationism, intelligent design, or anything like that. It just says, here's the theory of evolution. That's the scientific theory on the development and diversity of biological life. And what happened was, the way the controversy sort of first boiled to the surface is these board members were saying, we want to find, the reason we're not approving this is we want to find a textbook that balances. And what happened was, first of all, they couldn't find a standard biology textbook that balances. They actually considered, not very seriously, but Biology for Christians, which is a Bob Jones University publication. And after a long time, they did approve the standard biology textbooks, and Pandas was sort of like, okay, this is going to be the balance.
The second question I had was, what if there were just a regular textbook which taught the theory of evolution, but maybe it was even in a footnote that said, hey, this theory is not accepted as fact by some people and there are some problems, and it didn't mention intelligent design per se, but just noted that the theory is, in fact, only a theory.
First of all, and this is sort of an important public education point. The idea that it's a theory, not a fact, is really just a label, or a terminology that is incredibly misleading and unhelpful. Theory, I have a theory about, how to drive to Chapel Hill, which is sort of like a guess, a hunch. I think I can find my way there. In science, a theory means something quite different, which is, a well-substantiated, well-tested explanation for some natural phenomena. So when you say something, the best way to put it is a theory is better than a fact. A theory incorporates facts. A fact hopes to grow up to be a theory. So when you say a theory, not a fact, it is playing on the popular understanding of the use of the word theory to suggest that there's something problematic about it. And it's particularly problematic when you're just saying that about the theory of evolution and not about germ theory or plate tectonics, what have you. So, so first of all, that language isn't helpful. Second, Ken Miller's textbook actually said, hey, there's a lot of open questions in evolution. So no problem, there are. There's a lot of things we haven't figured out yet, and that will always be true. But there isn't a controversy in the scientific community about the fact that evolution occurs, that creatures living on the earth today have common ancestors as opposed to have been specially created, and that natural selection is an unimportant mechanism. So there isn't a controversy about that, and it would be misleading to students to say that there's a scientific controversy about that, which is what the Dover policy did. If you want to have a little footnote that says, historically there has been controversy over the theory of evolution because people have been uncomfortable about it for religious and cultural reasons, I think that's fine. How else are you going to teach if you ever teach the Scopes monkey trial in history class, you would have to say it's about this controversy. that there's a religious and cultural controversy, and putting that as a little historical note, in the textbook, just like you have a little historical note that the ship Darwin was on was called the Beagle. I don't have a problem with that. But it would be extremely misleading to portray to students that there's a scientific controversy over the theory of evolution. Niles Eldridge, who's a curator of the Museum of Natural History, just wrote about a book about Darwin. He said that in the scientific community, the theory of evolution is as controversial as the idea that the Earth is an oploid sphere that circles the Earth. It's not controversial, and the creationists and intelligent design advocates have created a public controversy that is not paralleled in the scientific community. Got off my soapbox.
I admit not knowing much about intelligent design, but it always seemed to me that whatever scientific criticisms you could have about evolution, which there probably are many, they apply with equal, if not 10 times greater force with the theory of intelligent design. There are things that evolution can't explain. Unless you're just willing to put it down to faith, that things intelligent design can't explain it. I would think it'd be sort of a theory in its infancy in terms of development. So I wonder if, the proponents of intelligent design have made any sort of efforts, or in this case, or ongoing efforts to sort of build up or develop the usual characteristics of what we would call scientific theory.
They've done almost nothing. My colleague Steve Harvey says, in some ways, why are we wasting our time? Intelligent design is an idea that's this big, and evolution's this big. Let's talk more about evolution. It's fascinating, and it really is. And they really, they have. It's really largely it's really comprised of two things. One is a negative argument against evolution. In other words, they say, well, look, evolution doesn't know this, evolution doesn't know this, so. And then the positive argument is this simple. If you walk in a field and you see, yes, it's the watch argument. I mean, it's you know, if you walk in a field and you see a field mouse, you would conclude that you know, that was something natural, or a better example is a stone. You know, you would just look and say that's the product of erosion. But if you saw a watch, you would immediately conclude it's designed. And we can do the same thing with life itself. When you see complex biological life, you can reach the same conclusion as you would about the watch. It was designed. That argument is so specious. I mean, and it made me crazy throughout this whole litigation. I just and I really spent hours figuring out what the best way to expose the absolute inanity of that argument in cross-examination. And the way I did it was, you know, and Professor Behe was advocating that argument, and I got him to admit, first of all, it's really the argument about the watch is William Paley's argument for the existence of God from you know, the early 19th century. And what I said was, you know, the science you're describing, the closest science to intelligent design that you're describing for this kind of reasoning is archaeology, right? And he agreed with that. And I said, and he said, so you know, when you're saying that, you know, archaeologists make a determination that, for example, a dug-out stone or a, you know, a sharp stone was designed as opposed to just being the product of erosion. He agreed archaeology was about the closest thing. And so then I went through all the different differences between archaeological reasoning and the reasoning for intelligent design. And you have to understand, in intelligent design, one of the things that they said, we don't know who the designer is. We don't know how they designed, when they designed, who it is. We just know it was designed. And of course, that is a way of avoiding the question of it's God, which most of them will sort of admit privately. And I said, you know, when you talk about archaeology, archaeologists don't go and pick something up and they say, wow, this was intelligently designed. No, they say, this was designed by a human. They start, I mean, that's their whole science is whether something was designed by a human. So that who the designer was is sort of built into the science. And then once you get into that question, well, you know, we know how humans do things. We know why humans do things. We know sort of the technological abilities they have at different points of time. We can actually recreate what we think a human might have done 5,000 or 10,000 years ago. Intelligent design, you can't do any of those things. And so, you know, and he admitted time and time again, you know, so there was no similarity, and it's really there's no scientific production. There's just a sort of a facade of a scientific argument.
In your opinion, why is there such a religious controversy over the theory of evolution? Because as far as I understand, the theory of evolution tells nothing about God and whether God exists or not, and whether God created the universe.
Right. I mean, I think, you know, it sort of gets to two issues. One is there are biblical literalists who want to accept the creation accounts in Genesis, and there are two accounts, but accept it literally. And evolution is, I think, inconsistent with that, in that I think it's inconsistent with the idea of special creation of humans. Is just one aspect. And then at sort of a more generalized level, people with religious concerns about evolution are uncomfortable. It sort of suggests we're here by accident. There's a purposelessness to life. You know, we're here, you know, because, you know, the course of 4 billion years, you know, got us, you know, from, you know, single-celled molecules to who we are. But that's just luck, and it's inconsistent with an idea of a, you know, a loving God who created us in His image. If you want to read more about it, we put out some a fact sheet and the article from Harper's, so you're welcome to take that. Thank you.